My name is Brandon Cathy. Brent Steinberg and I represent the estate of Jake Bell in this appeal. We're appealing from the granting of a motion for summary judgment in favor of U-Haul below. This issue is a lot simpler than the cases that preceded us, I think. The only issue here is whether or not the trial court erred when it ruled that a release that was signed by the estate of Jake Bell in favor of U-Haul, whether it erred when it ruled that it not only barred claims that existed at the time the release was signed, but also in ruling that it barred claims that accrued after the release was signed and that were based on acts that occurred after the release was signed. That is contrary, that ruling by the trial judge is contrary to both the release language and the holdings of a multitude of cases in Florida, including several from this district. Several cases analyzing release language that is indistinguishable from the language in this case have held that a general release of claims like the release in this case, although it bars claims that existed at the time of the release, it does not bar claims that accrue after the release or that are based on acts that occur after the release. Now, it's true in this case, the estate of Jake Bell did sign a release of the estate's wrongful death claim against U-Haul after a car accident. It's throughout the language of the release, there's multiple references to the death of Jake Bell and damages allowable under the Wrongful Death Act and that type of thing. And we concede that within that release there are clauses that don't limit this release purely to the wrongful death claim, but do give U-Haul more protection than just protection from the wrongful death claim.
Let me ask you, under the lease in this case, I don't have the whole thing in front of me, but it has what is sort of what I call Graves Amendment language in it. What was the extent of liability insurance provided to your client under the lease?
Well, Your Honor, we actually don't even have the actual lease agreement to know what particular lease agreement we're operating under. At the motion for summary judgment hearing, U-Haul...
What's the one that's in the record that I stole the page out of?
That is a random page that looks like a lease and perhaps may be the lease. But at the hearing on the motion for summary judgment, U-Haul had moved for summary judgment based on an interpretation it asked for under that rental agreement, saying that it didn't really owe any duties to the estate of Jake Bell. That it also wanted summary judgment based on this separate document, this release of all claims document. The court continued the motions for summary judgment as to everything except the issue of whether or not this release of all claims unambiguously releases the claims alleged in the complaint. And part of what the court addressed at the hearing was that we didn't have a copy of the rental agreement. We had some documents that were in tiny print like that. It wasn't a complete set of documents. We didn't have any way to know whether that was in fact the rental agreement that Vernell Butler got, or whether that's just a random rental form that U-Haul had. And so the judge ruled in a hearing that preceded this motion that we were entitled to do discovery, depose a corporate representative to find out where is this rental agreement, and once we get that agreement, how do we confirm this is the right one? So all that issue was set aside and not subject of the court's order. And so the release that was signed in this case, by its own language and by the precedent of both the Third District Court of Appeals and this court, does not release the claims alleged here. The claims alleged here are not claims based on wrongful death. They're not damages suffered by Jake Bell in the accident. What happened was after this release was signed in favor of U-Haul releasing the wrongful death claims, the estate of Jake Bell brought a lawsuit against a woman named Jane Wakeman. She was the other driver to the car accident. Jane Wakeman then countersued the estate of Jake Bell for her own personal injury damages. U-Haul, along with the auto insurer for Jake Bell, neither of them defended the estate of Jake Bell. This claim is, of course, against U-Haul for its failure to defend Jake Bell, pursuant to what we say the rental agreement would have required. It's also a second count for bad faith because they didn't settle the claim in spite of promises contained within that lease agreement that they would do that if a claim was presented. And so
I thought you didn't have a copy of the lease agreement.
We don't have a copy of the rental agreement that we know is for sure the rental agreement. We do believe, based on...
Sue them for bad faith under the provisions in the agreement, you don't have it?
Yeah, based on forms that U-Haul's used in other cases, and forms you can find online. If you go down to your local U-Haul, you can get a copy of a rental agreement that's in effect today.
Okay.
The-
All right.
Yeah, under those agreements, that's the kind of language that we're relying on. The language in this case that's at issue is the language that's in numbered paragraph 3. And I assume everybody's got a copy of the release of all claims. It's at volume 7, 1221 through 24. And the language at issue here is in numbered paragraph 3 titled Release of Claims. The language says, of course, claimant for and in consideration of the settlement amount, it releases, forever discharges, et cetera, et cetera. The released parties, down here in the middle of the paragraph, and then the language that's critical is this: for, upon, or by reason of damage to claimant arising out of the incident, or for, upon, or by reason of any matter, cause, or thing whatsoever, from the beginning of the world to the day and date of these presents. But that's the clause, from the beginning of the world to the day and date of these presents, that this court and others have interpreted multiple times. And in every single instance that a Florida court has interpreted this language, it has said that general releases with this language do not bar claims that accrue after the release is signed, and they don't bar claims that are based on acts that occurred after the release is signed, which indisputably is the case that we have brought here. Now, those cases...
Well, the act giving rise to the claim clearly occurred before the release, but you're saying there is a separate act or incident, which is the counterclaim?
Well, there's an underlying car accident. There is that. But the elements that the estate of U-Haul has sued for is breach of the duty to defend. That required a rental agreement, which of course preceded the accident. But then it required a breach of that rental agreement, which occurred after the release. It required damages to be suffered by the estate of U-Haul, which occurred after the release. And so when the courts talk about whether a claim has accrued, they're talking about whether or not all the elements of that claim have accrued either before the release is signed or after the release has been signed.
Let me make sure I have the timing of this correct. After the accident, the other one's name is Wakeman.
Wakeman, yes.
Was the suit by Wakeman brought before or after the signing of this release?
After. What happened was, after the release, the estate of Jake Bell sued Wakeman for wrongful death, and Wakeman then countersued the estate.
The duty to defend under the insurance portion of this rental agreement hadn't been invoked at the time the settlement was
Correct. Under the law of Florida, the duty to defend hadn't even arisen, much less had there been a breach in damages at the time that the release had been signed.
Okay.
Now, the cases that address this, there's a case called Sautier versus Gaines. That's a 3rd District Court opinion from 1973. In that case, the court, confronted with this same language, determined that a note, although that note existed at the time the release was signed, didn't actually mature until after the release was signed. They said this kind of release doesn't bar a claim based on that note, because that cause of action for default on that note didn't accrue until after the release was signed. In Hold is a case similar to this. Hold versus Manzini is another 3rd District Court of Appeals case. It's from 1999. That was a legal malpractice case. In that case, the act of negligence by the lawyers had actually already occurred at the time the release was signed. It was alleged that that lawyers representing this client had not properly advised the client about their exposure to fees under an offer of judgment, that they had immunity for some reason under a different statute. Turned out the lawyers were wrong about that, and the clients knew that at the time they signed a release of all their claims against this law firm. There had been a dispute over the amount of fees owed to the law firm, and resolving that dispute, the client signed a release of all their claims from the beginning of the world to the day and date of these presents. The court in Hold analyzed that and said, yes, while the negligence had occurred, though, it's the law of this state that a claim for legal malpractice doesn't occur until the actual damages are suffered. And although the lawyer had been negligent, there wasn't an actual judgment for fees entered against the client yet. So that claim had not accrued at the time the release was signed, therefore the release didn't bar that claim. This case cited to Hold and the Mulholland versus USAA case and several others for that same proposition. Mulholland versus USAA and Owens versus Nationwide would be the cases we would say are our best cases. Mulholland versus USAA was a case where it was a personal injury case where a client or an insured had brought a PIP claim against USAA, filed a lawsuit. USAA paid some money. to the insured and asked that the insured sign a release. The release didn't release the PIP claims, but it said we release any and all other claims, arising from the accident from the beginning of the world to the day and date of these presents. The court, the Mulholland then later brought a claim for saying I want my money. USAA said that's barred by this release of all claims. This court in Mulholland remanded the case to the trial court to say you have to determine when that claim accrued. If that claim had completely accrued at the time of the release, USAA is right, it bars it. If that claim didn't accrue until after the release, Mulholland can pursue his claim. Then in Owens versus Nationwide in 2004, this court examined a situation that's probably the most similar to our case. In Owens, Owens had brought a claim for uninsured motorist benefits, settled that claim for approximately $4,400, and again, signed one of these general releases of all claims. Subsequent to the signing of the release, Nationwide brought a brand new lawsuit against the tortfeasor, the underinsured motorist. It turned out the uninsured motorist had a $100,300 policy. But Nationwide brought the claim not only in Nationwide's name, but without telling Owens, brought the claim in Owens' name as well, and then secured a judgment only for the amount that Nationwide had paid. And so Owens then brought a lawsuit against Nationwide saying, hey, you breached our deal. You breached the policy. You had a subrogation right to pursue Nationwide. You didn't have a right to bring a claim in my name and then not even tell me about it. I'm suing you for acts that occurred after we had our release, things that you did after the release that gave me a cause of action. This court said again, they didn't use the word accrued claims in that case, but in Owens, not citing to Mulholland or Hold, said that claim could proceed because it was based on acts that occurred after the date of the release.
Let me ask you, and this is going to require some parsing of the language in paragraph 3, but in the first few lines it says, claimant does hereby release the released party from any and all manner of a bunch of things, including agreements and claims, whether in law or in equity, which the undersigned ever had, now has, or may have in the future, arising out of damage to claimant from the incident, or arising from any matter, cause, or thing whatsoever from the beginning of the world to the day and date of these presents. Doesn't the first part of what I read to you that contemplate that any future claim or lawsuit that accrued from the beginning of the world to the day of these presents would be barred, and I use the word accrued there, and doesn't it also contemplate that if you're going to bring a claim based on something that has occurred, it's barred? And I think what you're saying is, well, it didn't really occur because there was no duty to defend yet, there hadn't been the counterclaim yet, but that language is fairly broad. It seems to contemplate even a future claim that comes up. If it relates to something that's already happened, you can't do anything. You've released us.
Well, first off, the language doesn't use the word future. It says hereafter can, shall, or may have against the release parties for, upon, or by reason of damage to claimant arising from the incident, or...
Well, no, but a couple lines earlier than that, which the undersigned ever had, now has, or which he, she, or his or her heirs, personal representatives, or assigns hereafter can, shall, or may have.
Yes. Yeah, it doesn't say the word future, but it does use that language. And that exact language is in all those other cases we cited. That language about hereafter can, shall, or may have, that is in the Sotil case, that is in the Hold case, that is in the Mulholland case. That language is in general releases routinely. And I think that the idea there is what they mean when they say hereafter can, shall, or may, is they mean claims that you may hereafter discover or realize that you have. But it's still only claims where the elements of that cause of action had accrued at the time that the release was signed. And it certainly wouldn't include claims that where the acts justifying the cause of action hadn't even occurred. And so the language of this clause, including the hereafter language, plus from the beginning of the world and the date of these presents, appears in all of these cases. There's not been one case, and U-Haul's not going to cite you to one, that uses this language with from the beginning of the day and beginning of the world and the day and date of these presents, that ever, where a court in this state has ever permitted a claim that accrued after the date of the release or was based on acts that occurred after the date of the release. Now, U-Haul, there's two cases that don't actually.
5 minutes.
Okay. My 5 minutes is up?
Or you got 5 minutes left.
Okay.
Well, of your total 20.
Gotcha. Okay, so the second point to understand here is that there are two additional cases that don't even examine the language of release. One again from the 3rd District Court of Appeals and one from the 2nd District Court of Appeals, where they both say that just general releases, as a rule, cannot bar unaccrued claims, without reference to the specific language in the release. That it's just a rule, a general release can't bar an unaccrued claim. The Ciliberti versus Ciliberti case from the 3rd District Court of Appeals used the phrase, the release, it was talking about the general release, could not include a claim which had not matured at the time of its execution. So it could not do it, regardless of what the language said. And then in Winstar, this court similarly was evaluating a covenant not to execute and a general release, and whether those two documents, either of those two documents, barred a claim. And the court said in Winstar simply that a general release does not bar claims that had not matured when the release was executed, period. See Mulholland versus USAA. Now, in the trial court below, U-Haul argued that this language specifically, this catch-all phrase, from the beginning of the world, the claims that are anything whatsoever from the beginning of the world to the day and date of these presents, precisely was what barred this claim. Well, U-Haul now, perhaps in recognition of the law that's squarely against them, has done a 180 on that. They don't say that that language captures this claim. They acknowledge that our claims accrued after the release and are based on acts that occurred after the release. Instead, U-Haul asked that the court parse this sentence. They asked that the court, taking this phrase, following the second all caps release parties, where it says for upon or by reason of damage to claimant arising out of the incident, or for upon or by reason of any matter, cause, or thing whatsoever from the beginning of the world to the day and date of these presents. They say put a period after the word incident. Ignore that language at the end that modifies the sentence and just focus on damage to claimant arising out of the incident. Well, one, we can't ignore the language that follows it, but even assuming we could put a period after the word incident, this language still doesn't include the claims that we've brought here. Because when we read damage to claimant arising out of the incident, we have to also look to the definitions supplied in this release by U-Haul. So damage to claimant, the word damage is defined up in numbered paragraph 1. It says, claimant further alleges that the estate of Jake Bell Jr. and his survivors have suffered damages allowable under the Wrongful Death Act. Collectively, the damages. So damages are claims for damages under the Wrongful Death Act. There's no question we're not pursuing damages under the Wrongful Death Act in this case. Furthermore, they have to be arising from the incident. And of course, incident isn't described up above as simply the collision or things flowing from the rental agreement or anything like that. It is an incident that occurred on Interstate 75 near the intersection of State Road 200 in Ocala, Marion County, Florida, wherein Jake Bell was allegedly injured and died as a result of the automobile accident, the incident. So U-Haul's definition of even incident incorporates in the injury and death of Jake Bell, the things we are not suing for in this case.
If you're going to save any time for rebuttal, you probably need to sit down.
Thank you, Your Honor.
I'll save you 2 minutes.
Good afternoon. Troy Froderman on behalf of U-Haul Company of Florida.
Welcome to Florida.